Constitutional Court is set to deliver judgment in Busisiwe Mkhwebane's suspension as public protector. And this comes after President Cyril Ramaphosa appealed the Western Cape High Court's ruling last September that actually declared Mkhwebane's suspension unlawful. Now, the court ruled that the suspension happened the day after she publicly announced her Phala Phala investigation. But let's get you a sense of what else we should think about ahead of the Apex Court announcement later on today. Bring in political analyst Dr. Ongama Mtimka, who is with us now in studio. Great to see you, sir. Thanks for popping by.
Thank you, Ed. Thank you.
And there's plenty to think about when it comes to the story, right? Because it's been in the making for some time. So I suppose it's worth taking it back to its genesis, right? So the president goes to suspend the public protector. The Western Cape High Court finds that suspension unlawful. It is then the president who heads to the Constitutional Court, citing Section 172. On what basis is he going there?
Well, the genesis, obviously, of what brings us to a suspension in the first place are a series of findings against the public protector which trigger a parliamentary process, Section 194. Whose preliminary determination, I think earlier in 2022, is that it's worth investigating whether she should be suspended. She should actually be impeached as per Section 1943A of the Constitution. Now, when the finding from there determined that this is worth pursuing, the president started a process, I think, sometime in March to write to Busisiwe Mkhwebane. I think he felt aggrieved by the findings in the High Court, among them this issue of the hastiness of the decision and therefore how aligned it would be to an attempt to try and retaliate.
Right.
And then also this issue of whether or not there was bias. So I guess this is what the president is seeking to get from the Constitutional Court is in favor of the decisions that this had been a process that was underway as far back as March, and I remember his senior counsel arguing that there needed not to be a consideration in hindsight of the events, but rather the facts, in terms of what really happened.
Sure. It's interesting, the wording of Section 172. It speaks about the Apex Court making pronouncement on issues of constitutional invalidity.
Yeah.
In my untrained mind, that sounds like it is actually up to the Constitutional Court to confirm some of these issues. Is that how you also understand it?
Yeah, so on the legalities of it, as I was grappling with the arguments, my view was that this is going to be an interesting one for the Constitutional Court. And indeed, it's they who actually have to make a determination here on the constitutional validity, because there's a tension. Constitutionally, the president is permitted to make the suspension.
Right.
But the writing of the law didn't envisage a situation in which the president is directly conflicted on a matter, and hence the argument that it was illegal, because it was not just the basis of the findings against the public protector or the intention of Parliament to investigate in an impeachment process, but that the exercise of the right to suspend, which is written in tentative terms in Section 1943A, that the president may suspend any of those those Chapter 9 institution heads once there is a written correspondence that says that there's a process of investigation that takes place. Now, the writers of the Constitution didn't envisage a situation in which the president, in fact, may be compromised one way or another.
Yeah, and I suppose for a lot of people, what intensifies the complexity here is the timing of the suspension, right? The fact that the president made that pronouncement so close after the public protector, or at least her office, announced that they'll be investigating Phala Phala, and that's why you mentioned those perceptions that it's a retaliatory move, almost trying to, prevent the investigation before it takes off.
Yeah.
Optics-wise?
Yeah, so interesting, the two things about the optics. The broader political environment is that the president has had a number of gains politically, first in relation to the Ngcobo recommendation and what the ANC did with that. What was left next was going to be the report of the public protector, and then next would be the findings of either the Reserve Bank or the criminal investigations that are reportedly taking place within SAPS. Now, the opposition do want to have something arising from the legal issues with which to make President Cyril Ramaphosa to account. Because remember, if you understand, the balance of power in our parliament is that the opposition cannot effect any political change unless aided by a process that arises outside of the power play in parliament. So they need a finding that is going to be, negative towards the president in order to strengthen rational arguments for the president to fall on his sword with respect to Phala Phala, among other things. So this finding has got huge political implications as far as that is concerned. With hindsight, are you talking about the optics? We now, so this debate about the optics in retrospect has been had at the High Court, in fact also at the Constitutional Court. What's interesting now is that the optics are even more interesting, because the argument at the time that the president's defense were advancing in November was that the president stood no benefit from having suspended Busisiwe Mkhwebane because the investigation was going to continue anyway by his deputy. It's now complete, and in fact, with hindsight, he has benefited. Whether, and that's not to say anything about Kollega, his integrity, but the effect of the suspension is that he's benefited from it.
Is that correlation or causation? I suppose that's going to be the question asked, right?
Indeed. So the view would be that it's, and in fact this is where the optics argument was raised by his counsel, that when you look at the optics like that, it actually creates an impression of causation, when in fact the facts suggest that this is correlation or coincidence.
Sure. You mentioned the fact that, Parliament needs this kind of external finding outside of the power dynamics there to give
the opposition parties in Parliament.
Yeah, at least, yeah. But I mean, that's the Ongama report was that, right? And what was the outcome of that?
I'm happy you're saying that. You see, you're quite right. The Ongama report was that, but the ANC used parliamentary majority to crush it. However, there are always limitations as to how far parliamentary majority can succeed. If you look at the state of capture response and how Parliament was actually berated for having behaved in a majoritarian way rather than a logical way. So the more there's a strengthening of cases that affect at least the rationality of acting in a certain way in Parliament, the more the opposition benefits. Because remember, if the finding is not to the favor of the president, it increases the perception about what the risks were of having Busisiwe Mkhwebane, running the investigation, and the personal benefit the president would derive from this. And I can't remember now whether, in fact, those two areas in which the High Court didn't find in favor of Mkhwebane were the issues at the Constitutional Court. But that game theoretic, consideration of what happens at a legal space and what does it do for the opposition and in what ways does it limit majoritarianism is an interesting interplay of events that affect. And Parliament, by the way, has become a lot more conscious under Newzroom Afrika about appearing to be legal or not. So while majoritarianism may be used, but should there be something that kind of raises doubt about the rationality of defending the president, even when there's cases that are found against him, that may throw the ANC parliamentary caucus in tatters a little bit, or even divide it.
Okay, I can take divide, because I mean we do have, let's call it case law, right? We know there have been instances where even just, I suppose, ethically, morally, there is a clear direction perhaps that people might argue should be taken. But the parliamentary caucus, at least of the ANC, doesn't appear to consider that as much.
Over time, I would argue that it began to do so. So, you know, in that period of Umama Ubalagambete, there was a sense of siyaquba,
right? Yeah.
Regardless
of the party line. Yeah. So the party line.
But after the Constitutional Court findings, after the Zondo Commission findings, I've observed them, for example, as to how they respond when the EFF precipitates a crisis that compels Parliament to take action. How careful they are not to act in a way that suggests premeditated action, but would allow events in Parliament at the time to arrive at a stage where it is logical to take extra measures. So my view is that sensitivity to when can you take an action that is forceful, that is a power play, suggests that the latitude that used to be there to just willy-nilly siyaquba is no longer there, in my view. But anyway, we're running ahead of ourselves.
Yeah.
The court is going to make a finding. It's going to be an interesting one for the president. If it's to his favor, the political implications are huge. Because remember, I think it was Bruce, I forgot, he writes for Business Day. I don't know why I'm forgetting his, Whitfield.
No, Bruce Whitfield is on a different...
Peter Bruce. Peter Bruce.
Yeah.
He was right. He tweeted a very interesting thing recently, that notwithstanding whether the perception about whether or not Cyril Ramaphosa is coming or going, there is blood of his enemies throughout. And I thought, wow, this is quite interesting that this person who is causing panic for indecisiveness has had a lot of momentum of victories, you know, without his hands being dirty. So it would be interesting if this one also adds to that list of his enemies with bloodied nose. But where, for me, I'm paying careful attention is when institutions are taking decisions which cannot be justified. And my sense is that the public protectors one, and I'm running all around now, is not one of those institutions where there's no basis in the document itself to arrive at the decision that has been arrived at.
Right.
So my hope is that even the Constitutional Court, in the decision that it's going to make, there would be clear basis of, you know, how the decision is arrived at. What the thing to watch also is it going to be a unanimous decision?
Yes.
Or is it
exactly
some minority judgments as well?
I started off by saying there are multiple layers to it, and as you're speaking, you are taking some of them off as we go along. If it is a divided decision, we know how that could be used in some instances on the other side, you know.
Yeah.
We've seen it in the case against the former president, right? The fact that that wasn't a unanimous decision that sent him to court, which is a completely unrelated story, by the way, of course. But that divide works to both sides in some instances.
It does. And by the way, if the outcome is for the president, in fact, regardless, I hope that there isn't a unanimous decision.
There isn't?
Yes.
Right.
The reason why I say so is that the Concourt is under serious scrutiny under Chief Justice Zondo, and he has been unfairly accused of being a pro-Ramaphosa person. Now, interesting. So if the decision is made by a significant majority and there's one or two justices that differ, it is good, regardless of how it looks, because it then suggests that if there is capture, which I doubt, by the way, because all the time the Constitutional Court produces quality judgments that can be judged on the basis of the quality of the judgment. But it helps if there's some split, especially if the decision, the majority finds on behalf of the president. And it's chaotic for the president, but it helps because it would suggest that the court is not trying to manage optics.
Right.
It's open before the public, and has come with a divided decision if it's in favor of the president.
There's room for dissent even when the president's involved. I suppose that's the message we send. Ongama Mtimka, thanks for coming through, sir. As the cliche goes, let's watch the space.
Let's watch the space.
And have, I suppose, a whole lot more of an interesting discussion on the other side of that ruling. By the way, the Constitutional Court said to deliver judgment sometime this morning, definitely before 12 o'clock. If it is broadcast, catch it first here on Newzroom Afrika. Dr. Ongama Mtimka, thanks very much indeed for coming through.